Right, so what am I going to talk to you about today? Well, anyone who knows me know I only do tax, I don't do anything else. And I don't think Tony told me what I had to talk about, or if he did, I didn't listen. So what I've decided to talk about today, I'm going to talk about some of my favourite tax cases. But I have chosen these with you guys in mind, because I've thought about what your client base is like, and the type of people you will be advising, and thinking, well, will these cases be relevant? If they're not, I'm really sorry. The first one's on Entrepreneurs Relief. Who's interested in that?
Yep.
Yeah, good. PPR, yeah?
Yep.
Always a good one. We had a great session on that last year, didn't we? Amazing stories, like all those marriage breakups that happen around selling houses. Tragic. And then the last one I'm going to finish up with is on dividend waivers. How many people here use dividend waivers? Yeah, you know, yeah, they're good. Dividend waivers always good if they're used in the right way, but if they're not used in the right way, then they can be dangerous. So let's kick off with Entrepreneurs Relief then. We've got two interesting cases here. This first one is the Rice case, and it does concern cars. I don't think they're Tony's cars, but this is concerned Mr. Rice, who had a sole trade selling what you call performance cars. Now, I'm rubbish at cars, so I don't know what performance cars are, but I am told that these are boys' toys, like sporty kind of cars. And he ran this business from a property on Fletton Avenue, and within that property, he had a massive big forecourt. So he had to display all these cars. And the idea being, you're out for a drive on a Sunday afternoon, you pass a forecourt, go, oh, look at that car. And then you go in and buy the car. So he relied very, very heavily on passing trade. So displaying his cars and somebody would come in and buy them. The Fletton Avenue site was vandalised, and I have there that he ceased trading in 2005, although at the time the case went to tribunal, it wasn't clear as to when he actually ceased to trade. But when he gave up that trade and ceased that trade, he did go on to continue the business, and I use continue loosely, but it's selling a different kind of vehicle from his family home. So he was selling family cars and four-wheel drives. Now, as I said, I'm not really into cars, but I think I know the difference between a performance car and a family car. So a very different kind of market. And also, he relied very heavily on internet advertising. So he couldn't rely on passing trade, because what happened was when he started the business outside his own house, his neighbours complained, and the council closed him down pretty quickly. And he came to an agreement with the council that he could sell these cars from his own house, but he couldn't display any vehicles. So he couldn't rely on passing trade. And he was limited in the number of vehicles he could hold on site at any one time. So very much relied on internet advertising. So when he later sold Fletton Avenue in 2008, he said, well, I've sold my business premises, therefore I am entitled to Entrepreneurs Relief, and he claimed 10%. And that's where the problem went. Because the revenue came along and they said, well, no, actually, you're not entitled to Entrepreneurs Relief, because the premises you sold wasn't a business premises. Now, I put the law up there so you can have a look at this. You know, Entrepreneurs Relief, it's fairly straightforward. If you sell something that you can say is a business as 10%, sounds really easy. It's full of pitfalls. And this is one of the classic pitfalls. Because what you're looking at is, what is the disposal of a business asset? Because what did he sell? He sold his business premises, didn't he? Or he previously had used them as business premises. So what we're looking at, there's a material disposal where you have an individual makes a disposal of business assets. And if we come down, I've got at the bottom, where if we have a business ceasing to trade, if you cease to trade the business, then you must have carried on the business in 1 year, it must have been a trading business before you ceased, and then you must make the disposal within 3 years of cessation. Now the rules are different if you have a company and you have an asset outside a company. This is a sole trader. So you've got that 3-year window to sell off your assets. Now, this is where the debate was. When did that 3-year window start and finish? Now, this taxpayer, unfortunately, was not helped by his accountant, because his accountant, who had dealt with the disposal with him, put the wrong information in the letters to the revenue. So said things that were contradictory. So first of all, tried to argue that he had sold his whole business to these people. And he hadn't. He'd very clearly sold his business premises. Also, within the letter to the revenue, they gave the wrong date for cessation of trade. So the revenue said, well, you haven't made the disposal within 3 years. So what message do you take from that? Well, any letter you write to the revenue, could end up in front of a tribunal. And you need to go back and agree with your client whatever you're putting into that letter. When Mr. Rice went before the tribunal, he said his accountant never showed him any of these letters. His accountant just responded on his behalf. And it turned out that his accountant didn't know everything about Entrepreneurs Relief and he had to bring in somebody else. So, what was the issue at stake here? Well, both sides agreed that the disposal of Fletton Avenue took place on the 29th of April 2008. So they agreed that was the disposal date. However, there was 2 points in dispute. The first one is, was there a cessation of the original business? Because remember, he sold performance cars, and he's still selling cars, but he's just selling a different kind of car. And if there was a cessation of the business, when did that cessation take place? Was it within 3 years of the 29th of April 2008? I.e., was it after 29th of April 2005? Now, the date the accountant had originally given, I think, was March 2005, so it didn't help. It was 1 month outside that 3-year period. But Mr. Rice was a very good witness at the tribunal. So his appeal was allowed, and he did get Entrepreneurs Relief. Now, the reason he got Entrepreneurs Relief was, first of all, he was able to demonstrate that his business ceased in May 2005. Now, how could he demonstrate that? Well, as he stood in the witness box, he was able to remember his wife had gone into hospital, had an operation, he knew all the dates of that, and he knew that he ceased to trade just before that time because he wanted to look after his wife. And they knew the date in May that operation had happened. So that was very good evidence. But also, he was able to demonstrate that he had actually ceased the original business. Because although he was still selling cars, they were very different kind of cars, it was a different kind of customer, and the way in which he was getting his business was very different. He wasn't relying on the passing trade, he was relying on internet advertising, where somebody phoned up and said, oh, I see you've got a car on there, can I come and see it? They made an appointment and they came and saw the car. So his change in the business practices was enough to have a cessation. And there was also a gap between the businesses, because when the council closed him down initially at his own home and said he couldn't sell houses there, there was a gap while he got the correct planning to enable him to have the vehicles there. So what's the message you take away from this case? Well, if you have got a cessation of a sole trader business and you have got assets that you want to sell, you need to make sure that you sell those assets within a 3-year period. And what you need to be careful of as well, if you're selling part of assets from a sole trader business, you won't get Entrepreneurs Relief if you don't sell part of the business as well. So it's making sure it's not like taper relief. Taper relief is dead simple. It was if you had something that was a business asset, you could sell it and you got 10%. Entrepreneurs Relief, you need the business to go with everything, or you need a cessation. So I quite like that case. That's quite a nice one.
What would have happened if he was selling some performance cars along with the family cars?
Right, well, the revenue may then have, the tribunal may have found in favour of the revenue then to say, actually, you haven't ceased to trade, so because you haven't ceased...
10, 20%.
Yeah, well, that could have been the decision, because if they'd found he hadn't ceased to trade, then he wouldn't have got 10% tax rate. He was lucky, he went for a completely different kind of car, completely different kind of customer, and the way in which he sold it was very different. But you can see the kind of situations that would happen. You know, you've got nice big business premises, you want to wind the business down a bit, and someone wants to buy your premises. You know, so you'd have to think, well, you could do it by incorporating, so you cease someone, and you can engineer the cessation if you need to. If you have got a large asset, you need to get out. But the thing is, you can't plan in hindsight. You need to look at this from the outset. And sometimes the advice can be to the client, well, don't worry about it, we'll deal with it when the tax return comes up. And, you know, for my mind with tax, that's too late. You need to deal with these things before they actually happen.
If it constitutes a cessation, that would be a clear break.
Pardon?
If there was incorporation, that would be good enough. Under the same circumstances, if he carried on selling sports cars from his home through
a limited company, because you would have ceased one business and commenced another.
Even though it's clearly construction, it's the same in reality.
No, but you have to have a market value disposal. You might be selling the business across you cease as a sole trader. Because Entrepreneurs Relief doesn't follow through from sole trader into limited company. So you could do that.
Am I right in interpreting that he must have sold the last car in May?
No, you see, you don't have to sell your last car to cease to trade. What you do, you close your doors for business. So when you close your doors for business, go, that's it, I'm not trading anymore, you can sell off the rest of your cars to the newspaper. You're just disposing of your stock after you've ceased to trade.
Right.
And in fact, that's actually what he did do. He sold them through adverts in the paper. And I think he sold one person like 10 cars just to get rid of them. So this next case, this is a good entrepreneurs relief case. It's good, isn't it? Taper relief. Did we ever have a taper relief case? I don't think we ever did. Entrepreneurs relief, we've had quite a few. There was some last year as well. But the Corbett case is good, and this will be a case that may be relevant to you. Because so Mr. C was a senior executive employed by O Limited, and Mrs. C was employed by O Limited providing secretarial duties to her husband. Now, can I say, this is genuine, she really did work in the business. She did. A third party expressed an interest in acquiring the business, but the policy of that third party was, no, we don't, they actually used the term, we don't allow wives, not spouses, wives, to be employed in the business. So therefore, Mrs. C could no longer be employed in the business. Of course, Mr. C, he was a sales executive, he still needed these secretarial services, so his wife, although she was taken off the payroll, she was removed by getting her P45, she continued to carry on the exact same duties after she was P45'd off that she had carried on before. And then his salary was increased roughly, not exactly, I think they were trying to work out the next net tax effect here, but his salary increased roughly by the amount that she ceased to get. So as a couple, they still roughly have the same amount of income. O Limited was sold in October 2009, and Mrs. C claimed entrepreneurs relief on the sale of her shares. HMRC challenged her claim for entrepreneurs relief. So what grounds do you think they challenged this under?
She wasn't an employee.
She wasn't an employee, exactly. Now, if they'd walked through your door, you would have said that to them as well. So what we had in this case, we're looking at condition A there at the bottom, is throughout the 1 year ending with the date of disposal, the company is the individual's personal company and the trading company, trading group test, and the individual is an officer or employee of the company. So in that 1 year prior to disposal, you need to have been an officer or an employee. And if you're not, the legislation says you do not get entrepreneurs relief.
What if somebody, this sort of situation arises when there's a dispute?
Yep.
Somebody, a director maybe has been sacked, but the company nonetheless goes to a disposal.
Yeah.
The fact you've been forced out of the company, would the revenue have any legal
Well,
on it?
let me come on and we'll look at what they did in this case. Don't spoil the end of a good story here. We'll come on to it. So what's the issue here? Well, the issue is you've got an office holder, which is defined in legislation. So it's a position that exists independently from the person holding the position. So that's your director or company secretary. Or an employment, and an employment is defined as including any employment and under a contract of service. Now, in this case, the appeal was allowed. So that means the taxpayer got entrepreneurs relief, even though they were not an employee at the date of sale. Now, the reason that happened was that Mrs. C continued to carry out the same duties, although she'd been taken off the payroll. So she was an employee for the purpose that she was still performing duties, but she wasn't getting paid for it. And what swayed the tribunal was the financial controller of O Limited was a witness, and he was a very good witness. And the tribunal felt, well, he had nothing to gain by being a good or a bad witness here. It didn't affect his tax affairs, and he was very clearly able to state, you know, how she continued to carry on the duties, but the only way they knew to cease her employment was to give her a P45, so that's why they did it. Now, if they'd walked into your office and asked you whether they'd have a hope, you probably would have said, we can try, we'll try and enforce it because you had been an employee, we'll go with it to the revenue and see how we go. But you wouldn't have said, yeah, 100% we'll get you through on this one, because this is quite a strict test. Now, it is a good decision, it's a fair decision, but to be fair, if those people had taken tax advice before they did this, they needn't have got into this pickle, because she could have just transferred her shares to her husband and he would have got 10% and they wouldn't have had to go to the expense of a tribunal. So there was a much easier way to deal with this had they taken advice at the time.
If she'd been sacked,
yeah.
If, say, she unfairly say, would that have, well, I'm trying to get at it.
If you're forced out,
If you're forced
out, you see, you're not continuing to carry on your duties.
That's correct.
So what your argument would still continue to be is, I am an employee until I get my shares bought back. or if you're a director, you refuse to resign as a director. And I know they can take you off a company's house, but you can try and fight it. But the technical, so within the legislation, once you're not an employee or a director, your entrepreneur's relief will stop. And that's a massive risk. And it happens in a lot of cases where, I don't know, there's a row at a board meeting, someone throws their toys out of the pram, drops that and goes, that's it, I resign. And then they phone up you and they go, can you help me get my shares? And the first thing you say is get back in there and unresign quickly. And then we'll deal with it later. But you would never plan to be in this position. And I would say never plan on the basis of this case. Have you been following tribunal cases at the moment? They're absolutely crazy. They are seriously, some of the decisions that are coming out, they are not tax decisions. What they're coming out is you have non-tax people at the tribunals thinking, well, I think this might be a fair result. So it's really hard to know. It's a bit pot luck at the moment on some of the cases. Yes.
Because the lady, when she had to stop, was taken off the payroll.
Yes.
She was no longer under a contract of service, was she?
She was, but she wasn't. But because she continued to carry out the duties, they said she did have a contract of service, she just wasn't being paid for it.
Oh, an unwritten contract?
Yeah. So, which you can have.
Right.
But I get asked quite a lot, going, you know, well, my wife has shares in the business, can we say she was an employee although she never got paid and there's no evidence? If you haven't got any evidence, it's a very hard fight.
Right.
I had a director once who resigned as a director, continued to be involved in the business, and he had shares, and when it came to sell the shares, it was like, well, you're not a director. Right. And what we were able to pull together was a file of evidence that he emailed on a monthly basis, went to various meetings, and he still helped out with the company, and that was enough to persuade the revenue. Thankfully we didn't go to tribunal, but it was enough to persuade the revenue that actually his duties continued, although he wasn't a statutory director and he didn't get paid. But you know, you don't plan to be in these situations. No. Right, next case, PPR. We love PPR cases, don't we? There's been such a lot this year, I didn't know which ones to choose. So I chose two cases, I hope you like them. The first one is the Gibson case, and this, you know, this all involves a relationship. You know the way these things go. So Mr. Gibson and his girlfriend bought a house, Mole's House 1, we'll call it, because you're going to see there isn't a second house, in June 2003. His purchase was funded by a mortgage and a loan from a very nice friend called Mr. Reed. Mr. Reed, because he knew Mr. Gibson, he lent him the money as a good friend. And they hoped to be able to pay off some of the house from Mr. Gibson's girlfriend, Caroline. Her parents were going to give them some money, I think 300,000. And she was also going to sell her house and move in with them. So they thought, that's okay, they'll be able to afford this mortgage. Mr. Gibson consulted an architect about extending the property. They wanted to put in a new kitchen and a bathroom. And the architect said, you know what, you're much cheaper just to knock this whole house down and rebuild it. So that's what they did. And the house was much bigger than the previous house and much better, bigger footprint, and everything about the house was much bigger. But more importantly, it cost a lot more than they were expecting. So Mr. Reed lent them even more money. I think he in total probably lent them about 700,000 or 800,000. I have no friends that were that generous. But he lent them 700,000 or 800,000 pounds, and he funded all the additional building costs. And then Mr. Gibson decided, well, actually, do you know, we can't really afford this house. So the house was completed at the start of 2006. So you're looking at January 2006 it was completed, and it was sold in February 2006. So quite close. And he claimed PPR. Well, he didn't actually claim PPR. He just didn't put it on his tax return. So the revenue opened a discovery and said, well, hold on a minute, we think you've left something off your tax return here, like the sale of a large house. And he goes, really? I didn't notice. But the taxpayer lost his appeal. The tribunal said, no, he couldn't have PPR relief. Now, if you've got nothing better to do, you should read this decision. It's a great decision. Because, first of all, there was the tribunal chair and the other tribunal judge, and they didn't agree on everything anyway. So it's not entirely clear-cut. But what it was found was Mole's House 1, i.e. before it was knocked down, that was his PPR, because he did live in there, and I think Caroline may have moved in. Oh, they broke up throughout this process, in case I forgot that, but they are married now. So it's all back together, but that was partly linked to the sale. But Mole's House 2, which was the second house, what they found was Mole's House 2 was not his PPR. because he'd never lived in Mole's house too, although the estate agent does remember once showing people around and there was a bed in one of the rooms and there was a toothbrush in the sink. But other than that, there was no other furniture or anything. So that's what the tribunals are now seeing as camping out. It's not really living in the house. And by the time Mr. Gibson had occupied Mole's house too with his bed and his toothbrush, he'd already made his decision to sell the house, although he's not sure about that, and his witness statement was different to the evidence he gave when he was at the tribunal, and that doesn't help. And it was found that he had a history of buying and selling properties, but more importantly, he had a history of being a bare trustee for Mr. Reid, who was a bit of a property developer. And Mr. Reid did get some of the proceeds from the sale of this house. So you can sort of see everything in this case that really muddies it. But, you know, right, you probably would have told him that he wasn't going to get anything out of this, but there's a few important things coming out of here. Now, Mole's House 1 was his PPR, and he did live in there for a while. But because he went to tribunal without ever submitting a different computation to the revenue, the only thing the tribunal could do was uphold the computation the revenue had, which was capital gains tax on the whole lot. So he didn't get any allowance for the fact that Mole's House 1 was ever his PPR. But more worryingly, if the revenue start taking the approach, if you knock down a house and you rebuild it, there are two different houses, where does that leave us? So if, for example, your house is burnt down because you have a fire, and then you rebuild a house, and you may live in it for a short period, or you may not live in it, I don't know. But the revenue then could be arguing, well, hold on a minute, it was never your PPR, because it's a different house. So from that perspective, it's not a very good decision. The good thing about it is the issue as to whether or not there was one house or two houses was a split decision, and the chair got the casting vote. But yeah, interesting PPR one. Now, the other PPR one, this one I quite like as well, Dickinson. Now, this concerns Mrs. Dickinson had a large house and grounds, including a tennis court, over which she had planning permission. Now, the planning permission over this tennis court, just to put it in context, she had this planning permission for quite a long time. Because 10 minutes, oh, I'm going fast. So she had the planning permission for quite a long time. And the farm next door had planning permission to build houses, and she always thought, well, when they build those houses, they're going to want my tennis court because they want access, and there was a reason for having the planning permission. And every 3 years she had to renew this planning in order to keep it. But it looked like the development work was never going to be done at the farm next door, so she decided, well, actually, if they're not going to do it, we should do the development work ourselves, and we should build some houses on it. So she set up a company. She sold it to a company that she, her husband, and some friends formed to develop the land. Now, if you remember the rule, if you sell part of your garden at a time when you are still enjoying it with your PPR, provided it's within the permitted area, then you get your PPR relief. Really of the case, Barty case, it's going back years. So the idea is you sell the tennis court and you get your PPR. Now, unfortunately, there's a bit of confusion here as to when the actual sale happened, because the contracts were to be exchanged, but there was an agreement to exchange contracts, but the contracts weren't exchanged, and the diggers came in, and the diggers started to build up, to dig up the tennis court. So they dug up the tennis court and started to put down the groundworks at a time before the contracts were exchanged, which meant at the time the contracts exchanged, the tennis court could no longer be used as part of our garden. So you can see what the problem is now. But what's good on this case is the tribunal said, actually, you can have PPR, because all they've done is dig up your tennis court, and you could always put your tennis court back again, and it would be back to where it started. So therefore, we feel that it's only a temporary non-usage of your tennis court, so the tribunal allowed her to have PPR. Now, that was a lucky decision, because that's another decision where tribunals have probably looked at and thought, well, you know, if it wasn't for the solicitors messing up, she would have got PPR, but because they got their dates messed up, she didn't. So it just goes to show you don't know what way these PPR cases are going to go.
Always remember, no one likes solicitors.
No one likes?
No one likes solicitors, so that's
solicitors.
You don't like anybody.
So, have we got any solicitors in the room before you say that?
Yeah.
So be careful, get stoned. So what kind of things have you to be worried about for PPR? Well, you know, the courts are taking a good look at PPR now. The revenue are very excited by PPR because they can see there's money in this. And what they're looking at is, when you buy a property, what's your intention behind buying the property? It's no longer good to say that I lived in it, I had great quality of residence. If your intention was only to live there for 6 months, no matter how good the quality of residence, you're not going to get it. So you have to be able to demonstrate that your intention is permanent. And people go, that's ridiculous, you're never going to live somewhere for life. And I go, but you have to look like you're moving into it as the last house you're going to move into, not that it's a stopgap while you find something else. So intention's very important, and there was a case I went through last year with you where somebody moved into a 2-bed house that they previously rented, even though he was going to marry a woman with about 5 kids who could never fit it in the house. And the courts found, well, how could you all have lived in that house? So therefore, your intention could never have been there to be in the long term, unless you've really good bunk beds. But the other things to consider, quality of occupation. You know, make sure if somebody's living in a house, first of all, if they have electricity and gas, that really helps. The amount of people move into houses without electricity, gas and running water. You're making sure as well that you move your family in with you. Some people forget to move their families. That's quite tough. You're making sure that if you are saying you're living somewhere that you're not on paper driving your children 50 miles to school every day and back again, that you actually move the children as well. You're looking at your dentist, your doctors, electoral register, all those kind of things. And, you know, have loads of photographs of entertaining your friends and people coming around to your house and having barbecues, because that's what people do in their properties. And it's very hard to sit with a client in front of the revenue, but the client goes, no, we don't entertain. No, we've never invited anyone around. If you just think, no, you must. And yet they have no friends who can ever remember being to their house. The tribunal does take witness statements from people who've been to houses and stayed over and everything, as evidence that people lived in the houses properly. Right, last one. I'm going to finish up on dividend waivers. And the reason I'm going to finish up on this one is I get asked a lot of questions about dividend waivers. Personally, I don't really like dividend waivers. If you think you want to do a lot of dividend waivers, there's a better way to structure it. You know, you can use different classes of shares. Now, the next question, someone's going to go, how many classes of shares can I use? I don't know. There is no magic number. I would say do not use 26 classes of shares, A to Z, because that's far too many. But I'm quite relaxed if people use A shares and B shares or A, B and C. But if you have 5 shareholders, I don't like all 5 having different classes. So it's doing it in a sensible way. Very quickly, what this case involved, Mr. Donovan and Mr. McLaren, they were shareholders in a company together with the wives. I think the wives got those shares probably in about 2001. They didn't get their shares from the outset. So what they did was they would declare a dividend, an interim dividend, and the 2 husbands would waive their right to the dividend. And then the wives would take the dividend. And then 2 days later, another dividend would be declared, and the wives would waive their right to that dividend. So the way it was ending up, they were roughly getting about the same amount of money. But what the revenue looked at, they said, well, hold on a minute. First of all, you know, you're doing these dividend waivers, and we think that there's a settlement here. And the reason we think there's a settlement is because we've been through your accounts and we've added up your reserves, and had you paid all the dividends you were supposed to pay, then the company wouldn't have had the funds to pay them. And that's a big thing on dividend waivers. You can only waive a dividend if there's enough to pay everyone in the first place.
Paula, do you have to retain the capital in the distributable assets in the company afterwards?
Yeah, what the revenue do now is they actually go through and calculate over a number of years. So if you have like 4 or 5 years of doing dividend waivers, these guys were doing waivers probably 6 times a year, 6 or 7 years. So, you know, what they could have done from the outset, they could have given the 2 wives A shares and the 2 husbands B shares, declared different dividends, and the revenue wouldn't have batted an eyelid and would have had nothing to hold up. But because they did it going down the route of dividend waivers, it didn't help. Now, what also didn't help them was when they went to tribunal, they said they didn't want any witnesses and they had no witness statement. And then they turned up and said, actually, we've changed our mind, we do. And the revenue said, no, you can't do that because we asked you, you said you didn't want anyone. So then the court said, well, you know, they could, but they would have to pay for any delays and everything. And then they said, well, if you're going to do that, the accountant went, don't bother, we'll go ahead anyway. So they did go ahead. And then they started to say they did this for tax planning. And then they changed their mind and said they didn't. They did it to keep working capital in the business. Now, there's 2 things that come out of this. The first thing is, if you are going to do something like this, you do it properly with the proper documents. If you are going to tribunal, then you need to make sure you prepare for tribunal. You don't just rock up and then work out what your arguments are later and who you're going to bring in. Vaughan will tell you, he does loads of this. But you know, you need to be prepared when you turn up for tribunal. And know what your argument is. You can't go in and change your mind halfway through it. And, you know, while we know barristers will go in, and everyone expects them to be great, because that's their job, if you go in as the accountant, you think, well, I don't normally do this, so the tribunal will know I don't normally do this, they'll be a bit easier. They aren't. The way the tribunal's working, if somebody is paying you to do a service, then they expect you to do that service properly. And they will expect you to be nearly as good as that barrister. So bear that in mind. They're not very, very friendly places. So yeah, there's all the background on it and everything. But it was found that the amounts that had been waived went back to be taxed on the husbands. So they ended up with increased tax charges. So what do you need to watch out for? Well, if you're doing a dividend waiver, you know you can only waive the dividend before you receive it, or before it's declared. So you can't waive it afterwards, because then you're still taxed on it, even though you didn't get it. You can't backdate dividend waivers. There's a law of cheat, you can't do that. There must be a commercial purpose behind any arrangement. So it's fine, you may have shareholders who've been in the business a long time. They don't need the money, and they go, look, I'm waiving my right to dividend, just leave it in the company. And then that's fine. They're not intending that it goes to any particular person. There must be nothing in return for dividend waivers. And the company, the distributor reserves, that's where the revenue will go through over a number of years. And if you're looking at something around the settlements legislation, then what the revenue doing is saying, well, then it goes back to be taxed on the spouse. Now, very quickly, the Arctic Systems case, what did they do different in Arctic Systems? Well, in Arctic Systems, Mrs. Jones had a share, and she was given the share, and she got her dividends on that share. They weren't using dividend waivers. Now, looking at this case, you're all sitting there thinking they should never have got to this stage, and they could have handled it much better. You know, do odd dividend waivers, that's fine. But if you have a policy of always doing dividend waivers, then you need to look at changing around your share capital.
I don't understand that. How do you show a commercial purpose behind the waiver?
Pardon?
How do you show a commercial purpose behind it?
Well, it could be somebody wants to leave funds in the company. So it may be shareholders say, actually, I'm going to waive my right to a dividend because I know the company needs this working capital.
Do you have to prove that there was a gap in the cash flow or whatever?
Well, no, it could be just that you wanted to leave it in there. But what they were doing in this case, it was being left in and then going out. Right. So you couldn't say it was being left in because the money was all coming out, and they had joint bank accounts as well. So it was all over the place. Right, that's me. Thank you very much.